right. Hi, everybody. Still some people loading in, I guess. Let's see. I can close that out. All right, there you go. Hi, everyone. Nice to see you. Happy Friday. It's definitely summer, right? We're in August, and the weather is sure telling us we're in August. I saw some heat lightning last night, and it's been really, really humid. It feels like South Florida a little bit out there the past 2 days. Um, Hope everyone's doing well. Let's start with the dog of the day, who actually is a cat of the day today. We are still short of some dogs. It's nice to see Madeline out there. Look at this cat, beautiful cat. My gosh, almost like a show cat there. Beautiful, excellent grooming too, by the way. So the cat of the day is named Willow, and Willow belongs to Barbara Plycronis of First Service Residential. And I also, the name Willow reminded me of, if any of you know of Joan Armatrading, a very famous singer, Joan Armatrading. And this is one of her well-known songs, Willow. So if you don't know Joan Armatrading, she's retired now. She doesn't tour anymore. But if you go over to YouTube, you can see Joan Armatrading singing Willow, very well-known song of Joan's. So thank you so much there, Barbara. Beautiful cat. Nice green eyes too. So then we'll do my usual stupid lawyer announcements that I have to say so people don't sue me, I hope. Is that these webinars are for educational purposes. It's not legal advice. If you want to go out and get legal advice, you have to go hire a lawyer, sign a fee agreement, and all that fun stuff. And nothing will be kept confidential. So if you ask anybody any questions on this or put it in the chat, I'm going to talk about it. So don't be surprised when you say something and I talk about it on the seminar itself. But again, thank you so much for attending. I was really surprised. I thought 10 people would sign up today because I thought this topic was like a little boring and it's so nice out there. But I do appreciate you all being here. It's great. Saw some old friends signed up. I think I saw Ben Lambert on there somewhere, and I see Vicky Mittens out there. Hi, I've seen you in the emails out there. So it's always good. I saw Al somewhere, Al D'Amato. So it's I don't see him now. Maybe he dropped off. Oh, there he is, I guess. So it's good to see everyone, and let's just jump right in. So the first bullet point there is board decisions and board votes. So board decisions and board votes. I preach this. I've been preaching this for 30 years now. Everyone must keep in mind that board decisions to be binding must be made at an open meeting, a meeting open to attendance by the membership. It's amazing how often I get on the phone with somebody and they say, Fran, we haven't had meetings in 5 years. I'm like, are you out of your mind? Right? That's craziness. What are you doing? And then they say, well, we're totally transparent. I'm like, you're totally transparent when? Among the five of you? What are you talking about? So for board decisions to be binding, it must be pursuant to a meeting that is open to the members. And some people don't realize this, but it's not a big deal. All you're doing is sitting at the dais or the front table or whatever you're doing and making your decisions, and people can come in and watch. Can they vote themselves and say, no, I disagree. We're not hiring that snow removal. No, 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 no. Can you stop the meeting? No. Can you interrupt constantly? No. Right? All those things. It's not their meeting. It's a board meeting. Right? So it's a meeting of the board, not a meeting of the members, even though the members are allowed to attend. Hi, everyone. You're here. You're attending, but you're not doing anything. Right? That's a board meeting. And then we go on to the membership meeting. The membership meeting is totally different from a board meeting. A membership meeting is where the members meet and the members act. The members actually vote on things. And there are very few things that the members actually have to vote on. And here are some of them, right? I have them in the agenda here. Elections. So board elections, the members vote. They go send their ballots in there. They elect board members. They amend governing documents. So you pass bylaw amendments, you pass master deed amendments, you pass declaration amendments if you're in a homeowners association, things like that. They require membership votes. What about member votes for removal of board members? Yes, right. Removing board members generally requires a membership vote, although there are provisions in the acts right now that allow for boards to remove board members. I prefer that doesn't go that way because it definitely spurs litigation. I would prefer membership votes for board member removal, uh, but it's happening, and you're going to see more and more litigation in that realm over the next 2 to 3 years. That issue is becoming a hot topic because people are so contentious, so litigious, and in my view, so short-sighted. But anyway, membership votes are often required for board member removal. And really what we're going to talk about today is what votes are necessary under your governing documents if you want to special assess, borrow, repay, or spend money over certain limits. So many governing documents, many master deeds, many bylaws, many declarations, it really should be in the bylaws, but generally they are in the bylaws, but sometimes they creep into the declaration, sometimes they creep into the master deed. There are restrictions on whether or not the association can pass a special assessment without a membership vote, whether the board has the power to spend over a certain cap without a membership vote, whether the association can borrow without a membership vote, and whether the association can actually spend the money, even if it does have the money in its bank account for certain purposes without a membership vote, or over and above a certain amount without a membership vote. Okay, so these things tie the hands of boards in many respects when it comes to spending, and especially on the financial side of things. Why has this become such a hot topic? We all know this. It started with the Champlain Towers case, which is the worst example out there of an association failing to move forward and address the funding for structural repairs because they could not get the membership to pass certain votes, pass certain assessments. Okay, so what does this topic implicate today? So it implicates when the board can go forward, notwithstanding those membership vote requirements. So the next topic is emergency votes. When you're talking about emergency votes in association, it becomes a very gray area, and you're always testing litigation. And everyone knows what litigation means: taking a shovel, shoveling bunches of money into the middle of the room and setting it on fire, right? Because really all you're doing is you're not buying new trees, you're not helping, spruce up your detention basins or ponds. You're helping more lawyers make their mortgage payments, which is very, very nice. And I don't mind that. I don't object to it generally. But I would rather see people spend their money on enhancing the community, enhancing the lifestyle in the community, rather than sitting in court and spending tens of thousands of dollars, if not hundreds of thousands of dollars, on lawyers. Okay, so where does the emergency vote really, in the very beginning, trigger considerations? The business judgment rule. What is the business judgment rule? So the business judgment rule basically says that the board has the power to make decisions in operating the corporate entity, so long as it's authorized under the governing documents and there is no fraud or self-dealing. In addition, courts will impose what they say is a reasonableness test on the board's decision in some cases. So if the board can check those three boxes, right, authorized under the governing documents, no fraud or self-dealing, and reasonableness, generally speaking, a court or a judge will refuse to substitute her decision-making for the board's decision-making. She or he, whoever the judge is, will say, no, we're not second-guessing the board, and we are not making the decision for the board, and we are not sending this case to the jury. Because otherwise, in theory, we would have to second guess the decision for every corporate board out there, right? So generally, courts, as long as you can show that you've complied with the business judgment rule, will abstain from substituting their judgment for your judgment. So that's the business judgment rule. The fiduciary duty is kind of goes right hand in hand with the business judgment rule. The fiduciary duty for board members is what? The duty of care and the duty of loyalty. The duty of care and the duty of loyalty. The duty of care basically means that when members are making decisions, they get themselves reasonably informed with respect to the background of the decision they're making. You can do this in lots of ways. You can research things yourself. You can hire professionals to assist you, engineers, architects, financial people, accountants, etc. So that's your duty of care. You make yourself informed. The duty of loyalty is you do the decision making on behalf of the association rather than on behalf of yourself, right? I make a motion to hire blah, blah, blah as my landscaper because I think that person is the best landscaper, not because he's my nephew, right? And we run into these issues infrequently, but we still bump into them sometimes. So you want to make sure from a fiduciary standpoint that you're becoming reasonably informed and there's no self-dealing. If there is a chance of self-dealing, if there is a chance of conflict, you want to recuse yourself from the entire decision-making process. You don't want to participate in that decision, and you certainly don't want to vote on that decision. So I do have some clients where a board member has a family member who is also a vendor. That board member does not participate in any of the discussions, does not participate in any of the vote, and the remaining board members say, hey, we're getting a great deal with this person's nephew or son-in-law or whatever, and we're happy with it, and she or he is excluded from the decision-making process. So on to the emergency votes. It is very difficult to determine with precision what an emergency is and when the board can move forward with things like special assessments, borrowing, repayment, or spending, notwithstanding governing document sections that otherwise require a membership vote. Because most governing documents say that a membership vote is required for certain things, as I said, special assessments, borrowing, repaying, or spending. However, if there's an emergency, the board can go forward without the vote. The question is, what defines an emergency? Again, back to Champlain Towers. The law was amended in New Jersey after Champlain Towers, and I'm going to read it to you. I don't, as you know, I don't like to read, but I'm going to read it to you because this kind of sets the benchmark, if you will, for going forward when the governing documents require a vote, but there is a structural issue on the table before the board. So this is NJSA 45:22A-45A. And I'll read this slowly because it's worth thinking about. Notwithstanding the terms of the declaration, master deed, bylaws, or other governing document of the association. That's important. So that's the beginning of the statute saying, even if the declaration, master deed, bylaws, or other governing documents of the association say otherwise, and it goes on to say the executive board may, without the consent of the owners or approval of a developer selling units in the planned real estate development, adopt an assessment payable by the owners over one or more fiscal years or obtain a loan on such terms as the board determines are reasonable, and this is important, whenever necessary to fund the cost of corrective maintenance of the primary load-bearing system of the planned real estate development pursuant to section of the structural integrity law. Prior to adopting an assessment or obtaining a loan under this section, the executive board shall make a determination that the assessment or loan are necessary to maintain structural integrity of the building and shall obtain a written report from an engineer or architect licensed by the state that states that the failure to undertake corrective maintenance of the primary load-bearing system will constitute an imminent or reasonably foreseeable hazard to health or safety, constitute a violation of essentially the building code, or will result in a material increase in the cost of such corrective maintenance if delayed. So that statute expressly provides what is necessary if the association is going to go forward, notwithstanding a membership vote requirement in the governing documents, and the issue is structural integrity. So that makes a lot of sense. And we've talked about this before, even before Champlain Towers and even before this act, there was the Ritz condominium case down in Atlantic County where almost the exact same fact pattern as Champlain Towers. The association has a raised swimming pool over the parking lot, set up on structural steel members. The structural steel members were deteriorating. Uh, Good news there, though. The board got on it and had engineering reports and went forward with um, closing down the pool, redoing the structural work, special assessing, even though they didn't have a membership vote. They called an emergency, had a special assessment, and you know what happens. Some lawyer that lives in the building always jumps in and says, "No way, I'm not paying this. I know we didn't have a membership vote. Screw everyone. We should have just let the building fall down," right? And that's more or less what happened there. So the association passed the emergency special assessment. Um, let's see. The person's name was Melvin Thomas. Mr. Thomas, I believe, who was a lawyer, I think, says, no, you can't do that. And technically, he was right under the governing document. So I understand. I mean, I'm a nudgy lawyer myself sometimes, right? And I say, wait a second, you should have done everything, cross the T's and dot the I's. But what the court said there was, listen, the association had an emergency on its hands. Even though there was no statutory provision at the time, we had a pool that was going to fall down. Should we have let the pool fall down and undermine the rest of the building and have the building fall into the parking lot? No, that makes no sense. We're not going to allow that. So in Ritz Condominium versus Melvin, which is a 2011 case, the court said, yeah, you passed it a special assessment, but unfortunately for Mr. Melvin, he's going to have to pay it anyway because the association did it in good faith, and the association had an emergency on its hand. Basically had no other choice. It was a reasonable business judgment under the circumstances. So that's the easy call, especially now since more or less Champlain Towers and the Ritz condominium case are incorporated in that statute as to structural deficiencies, right? So that's nice. Okay, structural deficiency. But everyone goes, Fran, I'm getting these phone calls all the time right now. Fran, what about everything else? What if it's not a structural deficiency? What if it's not a structural emergency? All right, so then we look to kind of general standards. What about life, health, safety threat, but it's not structural? What about imminent harm, right? So something could happen to the structure. There's water getting in, but it's not threatening the structure right now, but it's causing a mold situation, right? We have a bad mold situation somewhere in the building. What about financial crisis? What about the association's inability to pay invoices and bills as they come due in the normal course of business? What about that? Is that an emergency? Or does emergency just mean someone could be harmed physically, bodily injury? What do we do with that? So that's the financial crisis part. The good news is we have another case, and there are lots of other cases out there that talk about these issues, but it's still not black and white clear. We have the Papello case from 1979, where we had Mr. Papello sued the Tower West Condominium Association saying, wait a second, you are doing a special assessment and a spending of a whole bunch of money. I think there the issue was spending. I think there was a vote for spending required. And you didn't get the vote. So Mr. Papello was a little more aggressive than the fella in the Ritz case. Instead of waiting and refusing to pay the special assessment, what he did was instead of what Mr. Thomas did, waiting to get the special assessment, he sued. He filed an injunction and a lawsuit to stop the association from moving forward with the project and collecting the money. And the court and talk about Tower West Condominium Association. This case, like I said, was 1979. I think I was just getting out of middle school at that time, but it's good that they were laying down the law for me. I don't, maybe Carter administration. Yeah, I think maybe. Yeah. So I was probably paying 10% on my freshman year student loans at the time. Now everyone goes crazy because interest is at 6%. You're like, what? Gosh, think about the 70s and early 80s. Anyway, that's interest and inflation. We're going to probably see that type of inflation again, by the way. I'm sorry. I apologize in advance for our government. But the Papello case, there was a lot going on in the building. What was happening? There was water infiltration through the facade. The place wasn't properly funded. They had failed to adopt proper budgets for years, and they were in a position where they could not pay their invoices in the ordinary course of business. They couldn't pay their invoices in a timely manner. So Papalo, which is a little different than Ritz, it included a bunch of things. It included physical structure. It included structural water infiltration that was damaging the building, but it also included issues involving financial, funding the association, funding the budget, paying vendors. So that's helpful because what happened in Papalo, similar to the Ritz case, was that the association went forward. And even though Mr. Papalo sued, the court said, no, Mr. Papalo, what is this board expected to do? They can't stop the water from getting in the building. They can't even pay their vendors on time. They must keep this building going. They have no option. That is a true emergency. That is a definition of an emergency in our mind. They haven't taken this money and spent it willy-nilly on other things. There's no evidence of self-dealing. We're going to allow this to proceed. And I think that's a good call by the Papalo court. The issue there is, again, the Papalo court discussed the business judgment rule. Is it permitted? It's permitted, but there should have been a membership vote. However, the board was acting under emergency circumstances. There was no evidence of self-dealing, and the board was acting reasonably. The board only assessed and spent money that was necessary to resolve the pending crisis. It didn't assess $1 bazillion just to, have a whole bunch of money to sit on. It assessed just to deal with the pending crisis. So that's case law that actually helps the association in case of emergencies. Why is this a continuing problem? Why? There's two reasons. One, you may be shocked to know this because I'm always preaching to the choir here. There are some bad boards out there who just want to use the emergency power as a rubber stamp to special assess, spend, borrow money, do whatever they want with the association's finances, right? And they go, it's an emergency. Golly, it's an emergency. We're going to spend money. Golly, it's an emergency. We're going to special assess again, right? Everything's an emergency. So there are some boards that are bad news out there trying to do that. Obviously, that shouldn't happen. I'm sure nobody on this call does that because otherwise you wouldn't even bother to be on this call. You're like, screw it. We do whatever we want anyway. Why would we listen to some lawyer on a Friday afternoon, right? So, so there's one part. What about the other part? The other part is the Mr. Papalo and Mr. Thomas part. There are people who feel very strongly, including me, that the association should comply with their governing documents, right? Should comply with the governing documents, right? That'll make sense. And if the governing documents say a special assessment should be approved by a vote of the membership of a majority or a supermajority or what have you, that should happen. If there's a vote requirement on the ability to spend, that should happen. If there's a vote requirement on the ability to borrow money, that should happen. All those things should happen, right? So it's a mixed bag. So I am regularly getting calls, especially from attorneys who are residents in associations saying, Fran, the board is proceeding on an emergency basis and they haven't had a membership vote, and I don't think it's an emergency, right? The rub there is, if I were to say to that attorney, okay, well, let's look at it this way. Would you be willing to indemnify, defend, and hold harmless the board if it does nothing and something bad happens? And of course, the phone line goes quiet because that's not going to happen. Nobody's going to indemnify, defend, and hold harmless the board, right? They want the risk to be on the board's shoulders, but at the same time, they want strict compliance with the governing documents, notwithstanding the fact that arguably an emergency is in place. So the question that becomes for all of us as we sit on boards, as all of you sit on the boards or you're managing associations, is do you err in favor of the emergency and removing the harm, removing the financial crisis, removing imminent damage, or do you err on the side of strict compliance with the governing documents? Most boards that I work with will err on the side of protection, safety, life, health, safety in particular, right? That's a no-brainer, life, health, safety. Okay, it gets a little more gray when you get to preserving property. It gets a little more gray when you're just funding and paying vendors. It gets a little more gray when you're funding reserve accounts that have been short funded for 20 years. But all of those things, in my mind, arguably could constitute an emergency under the proper facts. So when we get to the possible challenges to a board's determination of emergency, what do you see? You see a complaint in order to show cause for an injunction. So that was Mr. Papalo. So Mr. Papalo, he filed a complaint in order to show cause to enjoin the board from going forward with the spending program. He was unsuccessful, but there are people and there are cases out there who have filed these types of motions to stop the board, and the court has said, he or she is right. There was no real emergency here. The board should have gotten a membership vote. If that were to happen to your board, what do you immediately do? Even if that case is filed, you immediately go out to the membership and try to get a ratification vote, right? To ratify the decision, right? And you can ratify. Courts have recognized the ability to ratify votes. You have to do it properly, obviously, send out the proper notice of a meeting, have the proper documentation, etc. But you can ratify the vote. The second is a refusal to pay assessments. So again, that's the Thomas case with the Ritz condo. Mr. Thomas got a bunch of his buddies, and they just did more or less a rent strike and said, we think this is an illegal special assessment. We're not going to pay. And what happened there was, again, Mr. Thomas lost. But there are cases, I'm sure, out there where someone in Mr. Thomas's shoes may be successful. And again, if someone like Mr. Thomas is going to be successful, even if it comes up in the collection context, the board has to think about whether or not to go back to the membership and ratify the special assessment. As we sit here, I have a very large matter where the association proceeded years ago, before I was hired, with a special assessment that many believe should have had a membership vote. And we're in the process of going back and attempting to have a membership vote to ratify that special assessment that was passed, I think, in 2022. So it's dicey because nobody has raised the membership vote issue in the collections process, but they do have quite an arrearage. And we want to make sure that as we go to court, we don't have a Ritz condominium type case. Rejection by bank of underwriting. What does that mean? So if the association goes forward with a project that it believes is an emergency and it needs bank funding to fund it. So say the association needs $1 million to do something. The association's this emergency. We're going to go forward anyway. We're not going to get the membership vote. We're going to pass a special assessment. We're going to get a loan. We're going to repay the loan with a special assessment, and we're going to do the project. The bank will require a lawyer's letter, what they call generally an opinion letter, that says the association crossed all the T's and dotted all the I's in the process of passing the special assessment and obtaining this loan, right? So the weight then falls on me and the board to satisfy the bank's underwriters and make sure, confirm with the bank that the association has done everything necessary and there actually was an emergency. So that puts the heat on the boards and the attorney, unfortunately, to make sure there really was an emergency, really is an emergency, and it was necessary to address the emergency, because banks will not lend money, at least the banks I've seen at my sites, will not lend money without an opinion letter from counsel and perhaps even the management company that the process was undertaken properly. Counsel refuses to issue the opinion letter. So if your association attorney, whether it's McGovern or whoever, says, I can't issue an opinion that this rose to the level of emergency, and I can't issue an opinion letter, the bank is not going to do the deal. The bank just won't do the deal, because they're going to say, well, Fran, why would we buy into a lawsuit? So we go and lend you the $1 million, and then someone like Mr. Thomas goes, the special assessment is bogus, we're not paying, and there's a strike in terms of paying the special assessment. The bank's going to say, we don't care about your stupid arguments with your unit owners. We just want our loan repaid. And the board's going to say, yeah, but you have to understand Mr. Thomas and his friends are refusing to pay. And the bank's like, listen, I don't want anything to do with your silly dispute. Pay the loan. So that's why they want an opinion letter from counsel that says the special assessment's authorized, the borrowing is authorized, the project's authorized, and the spending's authorized. Okay. Um, so this is a new one for me. I just received it in a packet on Tuesday. Management Special Assessment and Loan Administration Standard Operating Procedures. So this is I won't say the name, but this is a large management company that now is sending out um, standard operating procedure requirements for association special assessments, requiring the association's counsel to issue an opinion letter, even when there's not a loan, just a special assessment that says the special assessment was properly assessed and this is what it was assessed for and this is what the money is being used for. So that must be coming down from their corporate counsel. I don't know. It's the first time I've seen it. I've never written a letter that says those types of things when there hasn't been a lender involved. I have not written the letter requested on Tuesday yet. I don't know if I will, but we'll see. So I'm going to have to talk to the management company's internal people and figure out what they're really looking for there and why they're looking for it. So that's kind of it in a quick nutshell. I hope that helps everyone. Where you're going to really struggle is defining the emergency and how emergent is it and which side of the risk do you want to be on. So what I call that is competing fiduciary duties, right? So you have a fiduciary duty to abide by the governing documents. You also have a fiduciary duty to protect the life, health, safety, and property of the association and its residents. And my advice typically is to err on the side, if you're going to err on the side, life, health, safety, property protection, right? Because doing otherwise puts you in the realm of Champlain Towers, which is nobody wants to be there. Okay. I thought we had a few questions, one or two. Can a board limit the number of times a resident can ask questions at a meeting without having passed any resolution to do same? Oh, yeah, thanks, Al. So the question is, I'll repeat it. Can a board limit the number of times a resident can ask questions at a meeting without having passed any resolution to do the same? I think yes. So I think the answer to that question, Al's question, is yes. And I don't think Al is talking about asking the same question, although some boards deal with that. This person comes to every board meeting and asks the same question month after month after month. And you're like, the answer is still no, Mrs. Jones. The answer is still no, Mrs. Jones. Can I clear cut all the white pines behind my home? No. Next month. Can I clear cut all the white pines? No. Right. So that's kind of easy. And I would just say, tell Mrs. Jones or Mr. Jones no every month. But I think what Al is really probably asking about is if I go to a board meeting and I'm in the audience, and so some boards will say, one question per person, and then you got to go to the back of the line, or three questions per person, then you got to go to the back of the line. And eventually everyone goes away. And then there's that one guy who's like, I have another question. I have another question. I have another question. And it becomes 75 questions. So yes, the board can limit that. And I don't think the board needs to adopt a formal resolution. The chair of the meeting runs the meeting. And the chair of the meeting, in my opinion, has reasonable discretion in how they run the meeting. In addition to all that, the board must act reasonably. And I think we would all love that the members act reasonably too. So it should be a two-way street. I know that sounds crazy suggesting that, but we would all like everyone to act reasonably. But that doesn't always happen. So if I was sitting on a board or if I was counsel to a board of an association and there was somebody who had, you get 2, 3, 4, 5, 6 maybe questions, I think it's fair to say, okay, you can send them into the management office and we will put them on the agenda for next meeting, or we'll entertain more questions from you, Mr. Smith or Mrs. Jones, at the following meeting. And I think that's fine to do. I think the board has the discretion to do that as long as they're acting reasonably, number one. And I know this sounds strange to add, but some people do wacky stuff. As long as nobody is discriminated against somebody based on protected class status, right? You can't do that, right? So you can't say everyone in the world gets 3 questions, but Mary Jones doesn't because we don't like people who have those ESA animals, right? We don't like that. We know you're just a faker, right? No, that's like, might as well drive up to Newark and write a check to the Division of Civil Rights right now, because that's what's going to happen. You're going to lose that. You're going to get crushed. So anyway, so you got to think about protected class status when you're applying those types of things. You have to apply standards reasonably. What happens when a board overspends for several years, then has a crisis for which they are lacking funds? Who is that? Sorry, I'm losing my eyesight here. Oh, it's Carlos. Hey, Carlos, thanks for the question. What happens when a board overspends for several years and then has a crisis for which they are lacking funds? If it's an actual crisis, the board has to determine whether it's an emergency, whether a membership vote is required, or it's such a crisis that the board has to go forward without a membership vote. If it's something where it's not doesn't rise to the level of an emergency, really, I think what the board has to work through is this something that justifies a special assessment, or is this something that justifies just an increase in the budget? Because I run into a lot of associations that, when I'm first hired, they proudly tell me that they haven't raised assessments in 10 years. And I say, you understand that that's financial suicide, right? And they go, what do you mean? We're the best board ever. And I go, but it's impossible, right? It's impossible to do that. That's just not, math is still math. It's unfortunately math is still math. And when there's an inflation rate of whatever the inflation rate has been, you can't have flat assessments for years, or you can't have spending over and above the budget for several years and not recoup that. So even though we talked a lot today about special assessments and membership votes, oftentimes the solution is just increasing your regular annual budget. I'm sorry. I mean, I know that's a very unpopular thing, and you as board members and management representatives, you have to go to these meetings, and the people stand in the back, and I have one coming up next week, and say things like, fraud, 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 you stole our money. Where'd all our money go? And as you know, nobody stole the money. It's just that they haven't assessed enough, right? Nobody, and there are cases, very rare cases, where there are people stealing money, but very, very rare. It's usually that the association has either, as Carlos may have alluded to, either overspent or underassessed. Again, it's just simple math. Martin says, establishing and maintaining an adequate capital reserve. Wait a second. Maintaining an adequate capital reserve fund is a requirement of the New Jersey Structural Integrity Act. It is not an emergency, but is it reasonable for a board to assess without a vote under that situation? So that's a really good question, Martin, without an answer right now. So Martin's question is, I'll read it again because it's an important question. Establish and maintaining an adequate capital reserve fund is a requirement of the New Jersey Structural Integrity Act. It is not an emergency, but is it reasonable for a board to assess without a vote under that situation? And I think the answer is maybe, right? That's the lawyer answer. Maybe. You have to look at the facts more. You have to get into the details of the facts. Couple things. Certainly, if you have a structural integrity type complex building, if you will, I think that argues very much in favor of authorizing funding those types of things, notwithstanding the lack of a membership vote. I don't know the particular facts of your instance, of your example, but I think that argues very much in favor of it. It may even constitute an emergency, right? It may even constitute an emergency, and I don't know the answer to this, so we will probably find out in a lawsuit one of these days. If the association is out of compliance with law, right? If the association is out of compliance with law. So there are some associations that you walk in the door on the first day and they say, reserve fund, what are you talking about? Right? They've been operating for 3 decades with no reserve study. It's like they've been under a rock for 2, 3 decades with no reserve study, no engineering study, and no funds in the reserve account. The question is it an emergency to assess to fund a reserve account up to today's balance? Because otherwise you're out of compliance with the law. You may have an action via the DCA, or you may have penalties of the DCA, and you may first face litigation and lawsuits from members or prospective members because you're out of compliance with the law. I don't know the answer. I think we're going to have a litigation on that. Um, but I think arguably, a board could say it's an emergency to collect the funds necessary to close the gap in the reserve fund. I think that's not a bad argument, but we will see a case on that. Um, Questions are based on the current agenda. Okay, yeah, thanks, Al. Al is saying I guess your example, I don't know if it's you or one of your friends, but Al is saying the questions that he's referring to in the earlier question are based on the current agenda for that board meeting. I think, Al, just because the current agenda has whatever 20 or 30 topics on it, doesn't entitle you to have 30 questions. The board, I think, can still reasonably administer um, the meeting based on the chair's discretion. Otherwise, the meeting would go on interminably. Do board meetings have to be open to homeowners, or can they be closed work sessions only? So, Pam, thanks for the question. It's good. This question never gets old, which is great. So, if the board wants to make a binding decision, it must make that decision pursuant to a vote at a meeting open to the members' attendance. There are 4 or 5 exceptions to that. They are attorney-client privilege, right? Attorney-client privilege. So they're making a decision, hey, Fran, let's come to this meeting. I want to talk to you. Offer them $20,000 to settle the case. That's attorney-client privilege. So that would be an executive session decision. Litigation privilege, which means it's similar to what the example I just gave, but the attorney's not there. You're not talking to me, but the board is talking about settling a litigation. Hey, board members, what do you think? I got a phone call from Fran last week, and he said he thinks we could settle this case for 20 grand. Should we do it or should we not? Should we offer them 10 grand? Okay, so that's litigation. And then the board says, I vote, we give them 10 grand, offer them 10 grand instead of 20. That's all closed session. Contract negotiations. Contract negotiations is the third type, where you have 3 roofing proposals in front of the board, and the board is going through those proposals and saying to one or more vendors, go back and sharpen the pencil, or this looks like the lead vote, or change the proposal this way, or how can we harmonize these bids? They're not bidding apples to apples. We need them to bid apples to apples, and that's not the way they're bidding. So those types of decisions, contract negotiations, or executive sessions. Personnel, hiring, firing, discipline, executive session decisions. We want to discipline Mary Jane because she's been showing up late. We want to discipline Bob because he hasn't been showing up on time. Those types of things. And then I've talked about this before many times. There's a catch-all number 5, which we call inherently private. That generally relates to collection cases, right? So Bob has not been paying his monthly assessments. I make a motion, we tell Fran McGovern to put a lien on his house and foreclose his house. That's executive session decision. And generally speaking, other inherently private things, generally that encompasses healthcare, right? So Mrs. Jones writes in, and I want a handicap parking spot because I have MS. That's usually the worst case example, because MS is a disorder that is not always apparent. And people freak out when Mrs. Jones gets a handicapped parking spot and she's walking fine. And they want to come to the board and say, hey, why does she get a handicapped parking spot? She's fine. She's a faker. She's a liar, blah, blah, blah. What the board can't do is go into an open meeting and go, listen, Mrs. Jones got her handicap parking spot because she has MS. No, can't do that, right? So the decision to grant things like handicap accommodations are made in executive session. Workshop meetings, are a different type of meeting. So they're not an open meeting, they're not a closed meeting. They're a meeting that are by definition are workshop meetings, but no decisions are made. No decisions are made. There may be a consensus decision made that, hey, Kenny, how do you feel about this? Oh, I would be in favor of that, I think. Mary Jane, what do you think? Maybe. Um, you know, Mahesh, what do you think of this? I would be against it. Even though that's a consensus poll and people are kind of voting, that is not a binding decision. That's just a workshop. Nothing happens. Generally, people don't take minutes. It's just talking. Where people get really hot after workshop meetings is if there's a consensus workshop meeting, and then you go out into an open meeting or an executive session meeting, and that person changed their consensus vote from the workshop meeting, right? So you have a workshop meeting, everyone on the board's like, yeah, we're all behind this. And you get out in front of the membership, and one of the board members goes, yeah, I changed my mind. No, I'm voting no. The other board members freak out. But that person is fine changing their vote because the vote has never happened. You see what I'm saying? In a workshop meeting, it's just pure conversation discussion. Um, all right. Bill says, can boards limit each member to 3 written questions provided to the board 3 days in advance? Bill, I think they can. I think they can. I think it's a bad idea. I think my experience with that type of thing is it's felt by the membership as overly restrictive, and too, I hate to use the word uptight, but too uptight. Um, and members do like to engage from the floor. Um, the unfortunate thing about this, and the reason why boards generally try this approach, the 3 written questions provided 3 days in advance, is, as Bill asked, is to prevent the gotcha question, right? Because we all know from being in these meetings, there's nothing some people like more than the gotcha to the board president, right? The question that they know nobody's prepared for, and they are like, wow, I know Kevin hasn't looked at these papers today. I'm going to get him with this gotcha question, right? I love that. Can I embarrass the lawyer in front of 200 people? That would be awesome. So even though I understand where you're coming from, Bill, and that type of approach does, tend to weed out the gotcha questions. I think it generally puts a bit of a wall up between the membership and the board and management and legal. So I think it's legal to do that. I just think it's oftentimes not a best practice. Erica says, can open meetings be done remotely? Do they have to be done in person? No, they can be done remotely. They can be done by Zoom. And even prior to COVID, board members were able to attend open board meetings via conference call, as long as both sides could hear the conversation. What should be done if the board president signs a proposal that says, once signed, the proposal is a binding contract without a vote in open board meeting? So that's Jackie. Yeah, thanks, Jackie. So this has come up with, I don't think it's come up at Four Seasons recently. It's come up at another large association, and it became a big deal with the DCA. One of the residents filed a DCA complaint, and the DCA representative at the time didn't understand where I was coming from. So I'll read the question again. What should be done if the board president signs a proposal that says once signed, the proposal is a binding contract without a vote in open board meeting? What should happen there is, so this happens sometimes, it shouldn't happen this way, but during a workshop meeting, the board talks about a contract, snow removal, and there's a consensus. Okay, the 5 of us agree we're gonna have LMS. I'm gonna agree on LMS. You in favor, everyone's in favor. Great. He or she has the proposal in front of him. He signs it. The question is that a binding contract? Is that a binding contract? My opinion would be no. My opinion would be no, that's not a binding contract. So Jackie's question is, what should happen? What should happen is that contract should be on the agenda at the next open meeting, and there should be a vote. Nothing should be undertaken under that contract until the open vote has been had and that vote has passed. The other thing I should add is Jackie's example is a good one because it happens all the time. It happens all the time. And boards get themselves in trouble. Why do they get themselves in trouble? Step away from my example and consider a different example. A board signs a landscaping agreement that says we are going to um, purchase and install 450 flowering crabapple trees to be installed along the association's entrance road, right? So the board president signs that proposal at a closed session meeting, and it never goes to the open meeting. The signed proposal goes to the landscaper. The landscaper, in reliance on that, goes out to the nursery and has 450 flowering cherry trees dug up. You will be stuck with that, right? As so long as the landscaper and the nursery reasonably relied on apparent authority by the board to do that thing, by the board president's signature. So that will almost certainly land you in litigation. And that's why what Jackie's describing should not happen. That should not happen. And just as a footnote to that, board members or managers, some associations have managers sign contracts and proposals. Proposals should not be signed. Proposals should not be signed. They should be sent over to legal to have a contract drawn up. Now, there are some exceptions to that, and boards can use their judgment. I'm not trying to generate legal work in terms of reviewing a bazillion contracts. But what we often see is we have boards, whether it was voted on in an open session or a closed session meeting, sign proposals, and then they call me up 6 months later when the work is being done and they're being billed, and they say, "Hey, Fran, we hate this vendor. This vendor's awful, and we don't have a contract." And I go, "What? You don't have a contract?" And they go, "No, we don't even have a contract. We never did a contract. We didn't feel like sending it over to you." And then the manager goes, "Whoa, wait a second, time out. I have a signed proposal here, signed by the board president." And I go, "Okay, send it over, scan it in, email to me." And I go, "You got a contract. I'm sorry, you have a contract. Whether you think you have a contract or not, you're bound to it." And then from the legal side, we have to try and fight our way out of that really, really awful contract. Because as you might imagine, those contracts that are typically presented by vendors, not all, but a lot of vendors. Did I say elevator vendors? Did I say garbage removal vendors? How about coin operated laundry? Oh my gosh. Well, if you want to look at a proposal that you should never, ever, 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 ever sign, those are the kind of contracts you want your lawyer to look at. That's not to say that you can always negotiate them, because oftentimes there are so few vendors available in a certain field, like elevator, for example, they may wind up stuck with their contract anyway. But it's worth running it by your lawyer. But if you do sign a proposal, 99.9% of the time, it's a contract and you're stuck with it. So I advise against signing proposals, and instead sending it over to the association attorney, who generally, and I know we do this in our office, takes it, throws it in the trash, and we do our own contract, right? We do our own contract. Let's see, back to the capital reserves question. There is a catch-up provision which should negate the need for a special assessment. Yeah, Wayne, the catch-up provision, I thought, was written out of the act in the 2025 amendment. I'd have to look at that. I'm pretty sure in the 2025 amendment, it took the catch-up provision out. So that I would have to look at. Wayne, if you need to talk about that, we can talk about it later. But I don't think we're into the catch-up provision from the statute anymore. Linda says, if the board is deciding about general maintenance that's budgeted, can that be decided in an executive session? No, 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 right? So if you're going to make a decision based on general maintenance, we would like to seal coat the roadways, which is a general maintenance issue. It's in the budget. That should be, I make a motion, we hire whoever, SO, to seal coat the roadways. And second, all in favor, aye. That's a great example of an open session meeting topic. That's where that should be. It should not be in an executive session. It should be in an open session. Everybody good? That was a quick hour. That went quickly today. It's what time is it? 1 o'clock already. And it's good to see everyone. What's the song? See you in September, right? See you in September. So look at Joan arbitrating and then play See You in September for me on YouTube after you listen to Joni. All right. Have a great weekend. Good seeing everybody. Take care. Bye bye.